Welcome, history and law students, to today's Explainer. We are literally stepping right into the engine room of Aotearoa, New Zealand's unwritten constitution today to uncover its hidden mechanics. We're going to explore how an 1840 treaty and an indigenous legal system that predates it by centuries are actively rewriting modern public law and statutory interpretation right now. It's an absolutely fascinating, continuously evolving legal landscape, and honestly, understanding it is absolutely critical for any student of public law. So let's get into it.
Here is our syllabus for this explainer. We're going to start with a systematic zoom in. We'll cover 1. A tale of two texts, 2. The Waitangi Tribunal, 3. Forging the treaty principles, 4. Courts and statutory interpretation, and finally 5. Tikanga as first law.
Okay, let's dive into this. Part 1. A tale of two texts, 1840 origins. To really grasp modern New Zealand public law, we have to start with the foundational tension that underpins the whole shebang. So, why can't we just use the treaty text? It's a really common question you might ask when first studying this area. If the Treaty of Waitangi is the founding document, why can't lawyers and judges just, read the text and apply it literally to cases today? Well, the simple answer is because there isn't just a single treaty text. We're dealing with two documents written in two completely different languages, carrying fundamentally different promises. And this brilliantly illustrates why a literal interpretation just completely failed. We've got a massive clash of contract interpretation here. In Article 1 of the English text, Maori explicitly cede sovereignty absolutely and without reservation to the British Crown. But over in the Māori text, Te Tiriti, which by the way was signed by the vast majority of rangatira, or chiefs, Maori granted kawanatanga. That translates to governorship, not absolute sovereignty. Furthermore, Article 2 of the Māori text guaranteed tino rangatira tonga, which means unqualified chieftainship and authority over their lands and tonga. So the English text demands absolute sovereignty, while the Māori text grants governance while retaining indigenous authority. Actually, if you think about it, a literal word-for-word interpretation of both texts simultaneously is legally impossible. Because of this massive disconnect, it's almost absurd to realize that the colonial legal system literally ignored the treaty for over a century. They even dismissed it as a simple nullity in a famous 1877 court ruling. But as we see here, the timeline of public law shifted dramatically in the late 20th century. Decades of Maori protest over land losses eventually forced the creation of the Waitangi Tribunal in 1975. That set the stage for the landmark 1987 lands case and eventually led to the creation of an independent Supreme Court in 2004, which was designed to resolve legal matters with a much deeper understanding of New Zealand's unique history. Which brings us to Part 2, the Waitangi Tribunal, investigating the Crown. This is the crucial legislative bridge that allowed modern courts to eventually interpret statutes through a treaty lens. In 1975, the New Zealand Parliament established the Waitangi Tribunal, and it's definitely no coincidence this happened the exact same year as a massive hikoi, a historic march from the far north all the way to Wellington protesting the ongoing loss of Maori land. This act marked a true paradigm shift in public law. It created a permanent commission of inquiry tasked with hearing Maori claims of treaty breaches. But here's the tricky part. How does a tribunal actually evaluate those claims, given the two conflicting texts we just talked about? Well, the 1975 Act legally tasks the tribunal with deciding the issues raised by the differences between the English and Māori versions. To do this, they obviously couldn't rely on literal translation. Instead, their findings and recommendations had to be expressed in a newly coined legal currency, which they called the Principles of the Treaty. So, moving on to Part 3. Forging the treaty principles, the judicial lens. Let's look at exactly what those principles are, because they became the vital, absolute solution for applying an 1840 document to our modern society. So the crucial point is that treaty principles represent the underlying spirit and mutual obligations of the 1840 agreement, rather than just the strict literal words. Over the years, the Waitangi Tribunal and the courts have forged several core principles. You have partnership, requiring the Crown and Māori to act in good faith; active protection, forcing the Crown to actively protect Māori interests and tonga; redress, which requires fair recompense for past breaches; and equality and participation, ensuring Māori have a voice in decision-making. These principles are what lawyers and judges are actually using in court today.
And that leads us to Part 4, Courts and Statutory Interpretation, the Judicial Revolution. This is really the climax of our explainer. It's how these historical and tribunal principles actually impact modern judges deciding cases right now.
Since the 1980s, the New Zealand Parliament has engaged in this quiet revolution by inserting references to the principles of the treaty directly into legislation. Today, over 35 statutes contain these explicit instructions. Take a look at Section 4 of the Conservation Act 1987, for example. It commands decision-makers to give effect to the principles of the treaty. I mean, this isn't just a polite suggestion. It's a hard legal requirement that fundamentally alters how public officials must administer the law, and, crucially, it opens the door wide for judicial review if they fail to do so.
But it goes even further than just those explicit statutory clauses. The courts have developed a really powerful common law presumption. Under the principle of legality, the Court of Appeal noted that judges will presume Parliament intends to legislate consistently with treaty principles. Basically, unless Parliament uses explicitly clear language to exclude the treaty, judges will interpret domestic statutes to be consistent with those principles. It has literally become a foundational baseline for New Zealand public law.
Now, what's really interesting about this slide is the sheer magnitude of this statement from Justice Cook in the landmark 1987 Lands case. This was the exact moment the Court of Appeal first defined the Crown-Māori relationship as a partnership akin to fiduciary duties. The Crown isn't just a generic government dealing with a generic stakeholder anymore. It's a treaty partner that must act reasonably and with the utmost good faith. This ruling forced the government to completely rethink how it transferred state assets, basically ensuring Māori claims weren't prejudiced, a real game changer.
Let's move to and see how this builds into Part 5, Tikanga as First Law, the next evolution. This is the final and perhaps most dynamic element reshaping public law today.
So, for a century and a half, the common law largely ignored the indigenous legal system that was already operating right there when the British arrived. That system is Tikanga. It consists of the complex customary rules, values, and practices that regulate social relations and maintain balance in Māori society. Legally speaking, Tikanga is the lex loci, New Zealand's first law. And importantly, it was never fully extinguished by the arrival of English common law. Today, we're seeing a massive sea change. Tikanga is increasingly being recognized by the courts as a very real source of common law. A perfect example for you law students is the recent Trans-Tasman case in the Supreme Court. In a major dispute over seabed mining, all 5 judges agreed that Tikanga forms part of the statutory phrase, any other applicable law. Think about what that means. It means even if a modern environment or planning statute doesn't explicitly mention the treaty, decision-makers are legally bound to factor Tikanga in. To really cement the sheer authority of this shift, we can just look to the words of Chief Justice Dame Helen Winkleman herself. She has explicitly acknowledged that Aotearoa's history is actively shaping its modern courts, noting that Tikanga's status as a source of law is just a reality of the modern legal landscape. New Zealand's constitutional framework is constantly reconstituting itself, driven incredibly heavily by this ongoing dialogue between the Crown's right to govern and Māori customary rights.
So, we've seen how a bilingual document from 1840, along with an ancient customary legal framework, have been translated by the courts into binding principles that dictate how modern statutes are interpreted today. But as we all know, the law never stops evolving. As you continue your legal and historical studies, I want to leave you with this. How will the growing integration of Tikanga reshape the future of statutory interpretation, judicial review, and co-governance in Aotearoa? It's a question that will absolutely define the next generation of public law. Thanks for joining me on this explainer, and keep questioning the mechanics behind the law.